other than to introduce John Cleary, who's our host for tonight. John is very well known as an ABC broadcaster for many, many years, and his Sunday night show was an institution, and with its kind of leisurely sort of conversations and going deeper than in the usual soundbite kind of manner of a lot of media these days. He's a very thoughtful thinker about the role of the media. He's been involved in the formation of Compass and on ABC board and staff levels. So he has a very broad understanding of those areas, and he's a great facilitator of conversations. So I'm going to hand over to John now to lead us in the evening's proceedings.
Thank you, Gordon, very much. It's a great pleasure to be here. I think this discussion, as Gordon has indicated, is what we hope might go in one direction, but now can perhaps go in another direction, and we'll all be very keen to hear when Frank Brennan says, "You may well say that, but I couldn't possibly comment." For those of you who do remember television programs of another era. It is a real pleasure to introduce our speakers this evening. Father Frank Brennan, well known to most Australians as a Jesuit, but currently CEO of Catholic Social Services Australia, a role of some great significance, particularly at the moment. Also, it's a pleasure to introduce Sharon Roderick. She's a researcher with the Institute for Civil Society and a media law lecturer, somebody I should get to know rather more well than I do, I think. And also our third participant, Robin Whittaker, a senior biblical studies lecturer at Trinity College and a regular contributor to The Conversation, one of the great media institutions of Australia. First, this evening, Frank Brennan will talk to us for around 20 minutes, followed by Sharon, and then Robin, and then there'll be time for questions. Frank Brennan, would you welcome Frank?
I should just mention for the questions, you need to actually put them, the address is to rasp at, what is it?
divinity.edu.au.
Sorry?
rasp@divinity.edu.
Yes, rasp@divinity.edu.au, and you need to do that by 7:30, please. So then they'll be sorted and then they'll be delivered afterwards. So sorry about that, but sorry.
Good evening, everyone, and great to be with you. And might I join you during this Reconciliation Week in acknowledging the traditional owners of the land on which we meet. This year, of course, is the 25th anniversary of the passage of the Native Title Act through the Federal Parliament. I had the great privilege of being in the public gallery in the Senate just before Christmas 1993 when that legislation was being passed. It was a truly historic moment. But I couldn't help thinking at the time that there were, of course, no Aboriginal people in the Parliament. And so the Aboriginal people were in the public gallery, and it was a white fella Parliament that passed this law. And happily, 25 years on, things have changed. And I think that might almost be something of a parable of what we're thinking about this evening, and that is the place of inclusion, the place at the table. Despite whatever differences we might have, how do we find that place of accommodation within contemporary Australian society? I feel I'm here a little under false pretences because I see that the flyer advertises religious liberty, the Ruddock Inquiry, an insider's view, what I know about the recommendations, but let me explain. On the 15th of February, I accepted Gordon's gracious invitation to come and speak about public religion, authentic faith in a pluralistic, democratically accountable society. And on the 6th of April, we set this date. And as of the 6th of April, we were pretty confident that we would have completed our work on the Ruddock Committee, that we would have delivered it, and that the government would have long published the report. As it turned out, you, the Australian public, were too interested in this topic, so there were about 20,000 submissions that were received. And also, as we travelled around the country, there was a lot of interest from various groups in sitting down and meeting with us. This meant, in the first instance, that we had to seek an indulgence and an extension of time. So instead of proposing a report by the end of March, we had to extend until the 18th of May. And then we were left in the situation where, given the complexity of the issues, they're still being addressed by the government. And as recently as yesterday, I spoke to the Prime Minister's office, and they still have not decided when the report will be released. However, I might note in passing that as I live in Canberra, I did receive an invitation the other day to an address to be given by Dan Tehan, who's a member of the Cabinet, and he is going to speak on matters of religious freedom on the feast of Thomas More in Canberra on the 22nd of June. So if I were you, I'd be watching that date. In order to set the context for this evening's discussion, I thought it might be useful to do three things. First, just to say a word about the setting of the contours of religious freedom under our constitutional arrangements. Second, to offer some reflections about human rights protections, particularly in light of the National Human Rights Consultation, which I was privileged to chair for the Rudd government in 2009, and then to make some observations about the plebiscite campaign and what we then looked at during the course of the Ruddock inquiry. Even those of you who are not constitutional lawyers would be aware that the Australian Constitution does contain a provision which talks about the relationship between the Commonwealth and freedom of religion. That's section 116. I'm one of those lawyers who had long wondered why our founding fathers had placed that provision, section 116, in chapter 5 of our Constitution, which deals not with the Commonwealth at all, but with the states. And the states are not even mentioned in section 116. So might I bore you with just a little legal detail about that? There was one of the great characters, one of the founding fathers, and I apologise to the women, but you'll appreciate they were all men there sitting at the table of deliberation back there in the 1890s. One of them was your classic Irish Catholic Australian, Patrick McMahon Glynn. He's the grandfather of the very esteemed Jesuit theologian of this town, Gerald O'Collins. Now, Patrick McMahon Glynn was adamant that God should be mentioned in the preamble of the Australian Constitution. The surprising thing for me as a lawyer, as I looked into this, was that I found that of the founding fathers, 3 of the key founding fathers who opposed any mention of God in the Constitution were Henry Bourne-Higgins, Edmund Barton, and Edmund O'Connor, all of whom later went on to the High Court of Australia. And Barton, of course, was our first Prime Minister. Now, it's not that they were anti-religious, but they were concerned to say God doesn't belong in constitutions. A constitution, they said, is a fairly secular sort of document. It's going to set out the distribution of powers between the Commonwealth and the states. And in fact, the only one of the founding fathers who later went on to the High Court to support such a proposal was Isaac Isaacs, who of course was a Jew. Now, as the discussions went on between 1891 and 1898, ultimately, those founding fathers who later became High Court judges, they got together with some of the other lawyers and they said, well, if God's going to be mentioned in the preamble, we have to ensure that this does not mean that down the track the High Court of Australia might find a way to allow the Commonwealth to start buying into questions of religion. So we'd better put in a provision to say the Commonwealth will have nothing to do with religion. And their argument was that's basically a matter for the states. And so they had a clause about freedom of religion in the chapter on states, saying that there would be freedom of religion, But then they thought, no, we've got to put in something about the Commonwealth there. And then at the last minute they said, and we don't want to interfere with the state's capacity to deal with religion anyway, so in the end it's just the Commonwealth and the states. You, as a Victorian audience, I thought might enjoy this little vignette of history. Back in 1897, when Patrick McMahon Glynn first suggested putting God into the Constitution, the strongest representation arguing for it came from the Presbyterians of your state, Victoria. And when ultimately Glynn's motion was lost by 11 votes to 17, none other than Dr. Rentoul from Ormond College here at Melbourne University informed the Presbyterian Assembly of Victoria, and I quote, "The mischief arose through a young Roman Catholic barrister being entrusted with the motion. He had not gone about it in the proper way." And I think that probably tells a lot of the story about freedom of religion in Australia over the last century. So what we had in the end in Australia was a decision to have a constitution, but not with a Bill of Rights, and a clause in relation to freedom of religion, which at its most the Founding Fathers saw as a means of ensuring that the mention of God in the preamble did not result in the Commonwealth buying into freedom of religion issues big time. And those Founding Fathers were so pragmatic, the reason many of them in the end agreed to put God in the preamble was they said, a lot of the punters won't understand this constitution, but if we put God in the preamble, they might vote for it. And so that was the basis on which it was done. So that's to set in historical context. In 2008-9, when the Rudd government was in power, the Labor Party at the time had watered down its commitment from saying that they would enact a Human Rights Act in Australia to say they'd have a consultation about a Human Rights Act in Australia. Well, you as the punters know the code for what that actually meant. Anyway, I accepted the invitation to chair the inquiry into that issue. Suffice to say that back in 2009, a significant number of key religious leaders in Australia said, we would not want a Human Rights Act, we would not want a piece of legislation which specifies these human rights, including the right to religious freedom, in part because we think that would give too much power to the unelected judges and take away the power from the elected politicians. And one of the strongest advocates against a Human Rights Act had been Bob Carr, who'd been the New South Wales Labor Premier in New South Wales. And I remember well, Bob Carr came here to Melbourne at a large event which was co-hosted by the Australian Christian Lobby to argue against a Human Rights Act. And he told this amusing vignette. He said, when I was Premier of New South Wales, I received in my office a visit from the Catholic Archbishop and the Anglican Archbishop of Sydney. They came in and I thought to myself, I've solved the Reformation. And we reached an agreement about the sorts of exceptions that should be enjoyed by religious folk when it came to discrimination legislation. He said, if you have a Human Rights Act, you can't do that anymore because it'll be decided by judges receiving very flash submissions from lawyers. And he was right. And that in part informed the view of some of the religious leaders back then to say, we don't know that we'd want something like a Human Rights Act. I don't think it's a party political point to say that 10 years on, particularly in the wake of things like the Royal Commission, but also in the wake of the recent census figures, which shows that Christian affiliation in this country is declining, those with no religion is increasing. I think that it would be generally conceded that the days of the two archbishops gathering behind closed doors with the Premier and shaking hands on what should be the exceptions in relation to non-discrimination legislation, those days have gone. And so we come to consider nowadays what should be the situation. Now, you'll recall that last year we had a plebiscite in relation to marriage. And yes, I was one of those religious figures in Australia who publicly said that I would be voting yes and indicated why I would be voting yes. Now, I come from the Catholic tradition of Christianity, so to those of you who are not Catholic, an apology for a moment. Robin, if I might just do a bit of Catholic theology.
That's all right.
In the Catholic Church, at least since the Council of Trent, there's been a view that marriage is one of the 7 sacraments. The sacraments are normally performed by priests, like myself, but the sacrament of marriage is performed by the couple themselves, exchanging their vows before God. Now, for the sacrament of marriage, it's necessary that a man and woman be free to marry, that they be committed to each other, and that they be open to the bearing and nurturing of each other's children. And if those conditions are not fulfilled, it's not a valid sacramental marriage. So that's one institution, if you like, in my faith tradition, a sacramental marriage. Now, there are a lot of people as philosophers, believers or not, who adhere to what we might call a natural law tradition, who say that in the natural law there is an institution of marriage. Whether or not you're Catholic or Calathumpian, whether you believe in sacraments, whether you believe in God, but that there is a natural institution of a man and woman who come together open to the bearing of each other's children, and that you might call marriage. There's then a third institution. Note, they all have the same name, and the third institution is marriage under the civil law of Australia, the Marriage Act and the Family Law Act. Now, to be very blunt about it and not disrespectful to those who have entered only into a civil marriage, that basically is a contract between 2 persons which is terminable on 1 year's notice by one of the parties. And it is not necessary that the parties have a commitment to the bearing and nurturing of each other's children. They may, in fact you'd often hope they would, but it's not necessary. So you can appreciate 3 different institutions which in the past may have followed very similar contours, but those contours have increasingly diverted. And it did seem to me that the time had come in Australia for the contours of civil marriage to be amended further so as to facilitate the possibility that people of the same sex might marry. Now, at the time during the debate, I had some discussions with some of our bishops, and I pointed out that I thought that the yes vote would be somewhere between 58 and 63%. Well, it came in at 62%. Now, given that it was going to be that, it seemed to me the questions were, how do we best protect freedom of religion? How do we maintain the standing of the churches in the public square, particularly in the wake of the Royal Commission? And how do we extend pastoral care and solicitude for everyone involved, particularly the children of same-sex unions? Now, as the debate went on, there were some who I thought too simplistically were saying, well, there's no problem with freedom of religion in Australia, and this is only about same-sex marriage. Well, guess what? Bodies such as the Human Rights Commission and the Law Reform Commission had been saying for years that the actual legal protections in Australia for freedom of religion were inadequate and were patchy. And that was in part because we didn't have a Human Rights Act. And it was because we didn't have a Religious Freedom Act. And it was because the anti-discrimination legislation had developed incrementally in Australia as a federal system. And so each of the states had their own discrimination laws, and the Commonwealth had a hodgepodge of discrimination laws, in part because of the constitutional issues that the Commonwealth didn't have the power simply to legislate across the board, overriding the states in relation to each and every aspect of discrimination. So, for example, they would implement a Sex Discrimination Act implementing an international covenant relating to discrimination against women, or a Racial Discrimination Act implementing an international covenant against racial discrimination. And so what we came to in Australia was a situation where, particularly at the Commonwealth level, it was said that the Commonwealth Parliament will legislate incrementally, implementing domestic legislation which is faithful to the international instruments that we've signed up to, but when it came to questions about freedom of religion, there was no Human Rights Act, there was no Religious Freedom Act, and so in the end, the way in which freedom of religion was respected in Commonwealth law was carving out what we call exceptions or exemptions within the Commonwealth discrimination law. Now, over time, I think this has meant that there's been a public perception that those who agitate for these exceptions are doing special pleading so as to be exempt from just the general law of the land. Nothing could be further from the truth. No, that was just the pragmatic way in which we had dealt with recognising the positive right to freedom of religion. And so when we had the debate through the plebiscite last year, it was important to emphasise that freedom of religion, the national architecture, the legal architecture for the protection of that, was inadequate and had always been seen to be inadequate. And so the question then became, well, does the recognition of same-sex marriage carry with it any particular additional problems because of this legislative framework? Well, the matter then came for resolution in the Parliament, and you'll recall that there was spirited debate, but in the end, people like myself publicly said, you don't go putting into the Marriage Act all sorts of provisions about freedom of religion. What you do with the Marriage Act is you put in provisions about marriage, particularly the ceremony of marriage. So yes, you can deal with some minor aspects of freedom of religion, for example, who can perform a marriage or who doesn't have to perform a marriage, on what property need it be performed or where would there be an exemption, those sorts of issues. But other bigger issues about freedom of religion we thought would be better dealt with once the issue of the amendment of the Marriage Act had been completed. And so the Prime Minister decided that what was necessary was to set up this so-called expert panel which could hear people's views on these sorts of issues. Now, 20,000 people indicated an interest and put in submissions or put their names to a submission, and we went around and we met with a couple of hundred different groups and experts, and so then had to come up with recommendations as to how best to deal with these questions. So perhaps I might conclude, I think I've got a couple of minutes, have I? 2. If I might just highlight one of the most vexed issues that was raised with us. People say, well, what licence should be accorded to religious institutions when it comes to the employment of people in educational institutions, where they say, we want to be able to run an institution which has an ethos, which is true to our religious sentiment, and we need to be able to employ who we want to. Now, as you'd appreciate, a whole range of views from those who say, well, if you want to do that, you shouldn't get any taxpayers' funds, to, well, if you're going to do that, there's got to be some explanation given to the public as to what you're up to so people can understand. Now, as I've often said, human rights doesn't have much hard work to do when you're dealing with what you might call your small L liberal religious educators. To take a parodying example of myself, yes, those Jesuits would go with anything, wouldn't they? But what about, and this is the test of human rights, What's the entitlement of the very conservative, evangelical Christian group that says, we want to run a school where, to put it bluntly, it's not taught, it's caught. We create an ethos where everyone, from the school principal down to the gardener, is someone who gets it in terms of what we're about, and we need to be able to create the ethos for us to be able to educate the kids as we want to. Is Australia tolerant enough? Is Australia big enough? Do we have the means to allow that to happen? If so, under what circumstances? For example, should you have to advertise publicly that this is your policy? And should you be able to demonstrate that your employment practices are consistent with your religious beliefs? Now, if so, putting aside maybe the case of where you're the only school in the area, is that a permissible expression of diversity in the Australian community, where you can ensure that people of different beliefs or different lifestyles would still be availed the possibility of creative employment and issues of that sort? So they're the things that need to be balanced. Because ultimately, what's important is this: to appreciate freedom of religion is a human right, so too is freedom of equality and non-discrimination. And the challenge for us is to have the appropriate legal machinery in place where we can effect the right balancing of interests and where we can create the environment where whatever antipathy there was last year, that we can move on together saying, let's live and let live, and let's enhance the tolerance that exists in the Australian community. So, I think that's part of the contemporary challenge for religious liberty. Thank you.
Thank you very much, Father Frank Brennan, and I'm sure all of you have been busy twittering away your questions or SMSing your questions to the address rasp@divinity.edu.au. You're about to run out of time. It's now a great pleasure to introduce the second of our speakers this evening. It's Sharon Roderick, researcher with the Institute for Civil Society and a lecturer in media law. Sharon.
Thank you, John. As John just said, I'm a research assistant with the Institute for Civil Society, and I speak on behalf of ICS tonight. ICS made a written submission to the Ruddock Inquiry into freedom of religion, and we also appeared before the committee. And in this talk, I'd like to briefly outline the issues that ICS regards as important in the current conversation that we're having as a society about religious liberty. And the first point is to emphasise the critical importance of freedom of religion as a foundational human freedom. And in the words of Os Guinness, freedom of religion and belief affirms the dignity, worth and agency of every human person by freeing us to align who we understand ourselves to be with what we believe ultimately is, and then to live, think, speak and act in line with those convictions. Nothing comes closer to the heart of our humanity than the self-understanding and the self-constitution made possible through this freedom. The second point I'd make is that freedom of religion is not just about the freedom to believe. It's not just what's between our ears, what we believe, nor is it confined to the freedom to worship at a church or synagogue or temple or mosque. Article 18 of the International Covenant on Civil and Political Rights makes it clear that freedom of religion encompasses, and I quote, the freedom, either individually or in community with others, and in public or private, to manifest one's religion or belief in observance, practice and teaching. And the state parties to this covenant, which include Australia, also undertake to respect the liberty of parents to ensure the religious and moral education of their children in conformity with their own convictions. So it's clear from Article 18 that freedom of religion extends to our conduct, both personal, corporate, parental and public. Having said that, as Frank's just mentioned, like all human rights, freedom of religion is not an absolute right. The manifestation of this freedom must be subject to limitations that are necessary to protect other rights. And that's where the rub is. When they intersect, that's where the tricky issues start. The third point is that although freedom of religion enjoys significant protection under international law, it doesn't enjoy sufficient protection under Australian law. In fact, its protection is relatively weak. There are currently only two main sources of recognition and protection. And the first, as Frank has just explained, is Section 116 of the Commonwealth Constitution, which prohibits the Commonwealth from making a law that establishes a religion, imposes any religious observance, prohibits the free exercise of any religion, or requires a religious test as a qualification for any Commonwealth office. Section 116 prevents Australia from establishing a state church, but it doesn't amount to a constitutional guarantee of the right to freedom of religion, nor does it give individuals a right of legal redress if it's infringed, and it only restricts the Commonwealth's powers, not the state's legislative powers. The second form of protection is an exemption that religious bodies enjoy from anti-discrimination laws to which they would otherwise ordinarily be subject. Religious bodies are allowed to apply a religious values and conduct filter when making employment decisions. For example, a religious school might be permitted to discriminate between applicants for employment on the basis of their religious convictions or lack thereof. These exemptions are only accorded to religious bodies and in any event are under attack by some human rights advocates. And I understand that many of the submissions to the Ruddock inquiry have argued that they should be removed, and I believe that's the Greens' policy as well. I would also add that in several Australian jurisdictions it's unlawful to discriminate against a person in certain contexts, things like employment or education or the provision of goods and services, on the basis of their religious belief or practice. So this is not a protection of freedom of religion as such, but it's a right that religious people enjoy. However, this right to non-discrimination is not afforded to people in the Commonwealth, South Australia or New South Wales anti-discrimination law in terms of religious belief and practice. And in its 1998 report on freedom of religion, the Human Rights and Equal Opportunity Commission concluded that the degree of protection afforded under Commonwealth, state and territory laws was, quote, relatively weak compared to many other countries, and that Australia did not satisfy its international obligations relating to freedom of religion and belief. And ICS echoes these sentiments, and we would add that this weak protection has resulted in a degree of imbalance between freedom of religion and other human rights, particularly equality rights. And as I think equality rights in some scenarios are beginning to trump what I'd call the liberty rights of freedom of religion, freedom of expression and freedom of conscience and association. Our fourth point is that freedom to manifest one's religion is under threat in Australia. ICS accepts that Australians currently enjoy the freedom to believe and worship, but we're becoming less free to manifest our religious belief in speech and conduct. For example, education and workplace policies and contracts and commercial or social pressure are at times used inappropriately to silence people from expressing or acting on their religious views, where those views conflict with secularist agendas. And any serious consideration of religious views in the public square is often minimised or even eliminated. And there have been numerous instances in Australia and overseas where persons who have expressed a concern or opposition to issues such as abortion and the Safe Schools program or the gender debate have been either dismissed from their employment, demoted, or have undergone disciplinary proceedings at their university, or have been forced to resign from private directorships on the grounds that their beliefs were not inclusive or created an unsafe workplace or environment. Little concession has been made in some of these instances to the right of these people to express their religious convictions on such issues and to align their conduct with those views. A case in point is Dr. Pansy Lai, who spoke out against the Safe Schools program and was then subjected to a social media campaign to have her deregistered as a GP. The same goes for Dr. Stephen Shavura, when a social media campaign called for his dismissal from the Macquarie University because of his association with the Lachlan Macquarie Institute. Another recent case in point is the Australian university student who said, when asked, that he would show love to a gay friend but not necessarily agree with their lifestyle. The student was then suspended from the university for at least one semester, pending a review, and had official disciplinary action recorded on his transcript for allegedly making his classmates feel unsafe. Lawyers then represented this student in his negotiations with the university and ultimately secured a reversal of the decision, which enabled the student to return to his studies without detriment. Governments and public authorities, not so much in Australia, but certainly are there examples overseas, are increasingly excluding religious voices and practices from their domains and discriminating against them in funding, licensing, and in the provision of economic and other benefits where these religious views or practices conflict with secular agendas. A third example of the threat to freedom of religion in Australia in terms of its manifestation are vilification laws, which render conduct unlawful if it's reasonably likely to insult or offend a person on the basis of a protected attribute. These laws can be used to stifle the expression of religious views about a protected attribute, even where the view is expressed in a reasonable and moderate manner. And I'm sure you're all aware of the well-known Archbishop Porteous case, where the Catholic Archbishop distributed a booklet outlining the Catholic position on same-sex marriage to parents of Catholic school students. And this was held by the Anti-Discrimination Commissioner in Tasmania to be a possible violation of Tasmania's anti-vilification legislation. So the matter proceeded to a conciliation session but was eventually abandoned months later by the complainant. This hasn't been an isolated incident in Tasmania. Complaints have also been made under the same law against Presbyterian minister Campbell Markham and street preacher David Gee for expressing traditional Christian teaching on homosexual relations and marriage. So effectively, our concern is that the use of these anti-vilification laws, if they're fairly low bar, can turn a disagreement about the morality of certain conduct into a legal weapon to silence opposing views in public discourse. And, domestic law has also failed to guarantee parental rights to ensure the religious and moral education of their children in accordance with their religious convictions, despite the fact that this right is enshrined in Article 18. Given that we believe freedom of religion enjoys fairly weak protection in Australian law and that the threats are mounting, ICS has taken the view and argued that the following legal protections are needed to try to accord greater protection to freedom of religion, but at the same time without trammeling on others' rights. And our first argument was that we ought to maintain the right of religious organisations to consider a person's adherence to the beliefs and way of life of the religion when making a decision as to whether to employ that person, despite any contrary anti-discrimination laws. This right would facilitate the right of religious organisations, such as charities and schools, to coalesce around their ideas and beliefs as to what constitutes the best way to live and what makes for a prosperous society. Voluntary associations in a free society should have a right to hire and retain people who are ambassadors for their cause. And to force them to hire persons who are not ambassadors for their cause poses a threat both to freedom of religion and to freedom of association. We'd emphasise that the purpose of affording this freedom or this right is not to give religious organisations a licence to discriminate for the sake of it. Rather, it is a recognition that organisations must be able to associate with like-minded people around a particular ethos or mission in order to be able to advance their cause and maintain their character and distinctiveness. It's an existential issue. Any attempt to oppose micro-diversity within voluntary organisations is a threat to diversity. We don't insist on it in the political realm. We don't, for example, require the Greens to employ or recruit climate change deniers in order to have a rounded and representative view on climate change issues. We don't require the Labor Party to recruit capitalists or big business in an effort to ensure micro-diversity within the party. We accept that clubs should be able to exist to serve particular ethnic groups. So why should we seek to do otherwise for religious organisations? And it cuts both ways. The same right should be extended to non-religious organisations whose mission is to present to the public a worldview and way of life of a non-religious community. Secondly, we would argue that the bar should be lifted on anti-vilification laws. We believe that the Federal Parliament should provide that the expression of a genuinely held religious belief about the morality or propriety of any conduct should not be unlawful, provided it's done in a manner that does not intimidate, incite violence or hatred against, or threaten the physical safety of others. And of course, the same freedom should be accorded to those who wish to critique religion. Thirdly, we believe that religious belief should be added as a protected attribute in anti-discrimination law in all jurisdictions, particularly at the federal level. However, if this was to be the only form of protection recommended by the Ruddock Report, we believe this would not be a sufficient solution to the problems that we've outlined. For example, anti-discrimination laws only protect persons from comparatively unfavourable treatment. They don't protect companies or associations or partnerships. And they only protect persons from detrimental treatment in certain contexts. Moreover, they typically exempt from their operation anything that's authorised by a statute or bylaw or court order. So, for example, if a local council made a bylaw which had the effect of imposing a detriment on persons or organisations that, for example, held a belief in traditional marriage, this bylaw would be exempt from the operation of most anti-discrimination laws. Fourthly, we believe that parents should have a right to have their child excused from school classes which are antithetical to their religious and moral convictions on sexuality or gender, just as parents should have a right and do have a right to remove their children from RE classes. Implementing this recommendation would require the Safe Schools material to be isolated and contained rather than embedded throughout the curriculum. Finally, we believe there should be a statutory limit on government interference with freedom of religion. This could take a number of forms. It could be based on Article 18, which provides that the freedom to manifest one's religion or beliefs should be subject only to such limits as are prescribed by law and are necessary to protect public safety, order, health, morals, or the fundamental rights and freedoms of others. Finally, we would emphasise the need for a renewed understanding of what tolerance entails. True tolerance is not the same as avoiding conflict. It doesn't require religious people to agree with, celebrate, or be publicly silent about views or ways of life with which they disagree. In fact, people of faith should be both prepared and permitted to disagree in a forthright, robust, and public manner. True tolerance does not mean never giving offence. Reasoned disagreement with another person about a matter which they regard as core to their identity or worldview may well result in them feeling offended or insulted. But an offended response does not turn a simple disagreement into intolerant speech. True tolerance is about respecting the other person's right to be wrong in our eyes and to uphold their right to express themselves, even when we strongly disagree with them, and that cuts both ways. With that in mind, it behooves persons expressing religious views to do so with humility and gentleness and respect, not in ad hominem or prejudice attacks. Do unto others as you would have them do unto you is a good rule of thumb for respectful disagreement. And any offence should not arise from the manner and tone in which we have expressed our views. True tolerance ultimately can't be secured by laws. Laws can and should facilitate or restrict certain behaviours, but on their own they're powerless to create a culture of true tolerance and respect. And I believe that we have a lot of work to do as a society to promote this kind of culture. Thank you.
Thank you, Sharon. Again, a reminder that you've got just a few minutes to SMS your questions to our panel. It's now my pleasure to introduce Robyn Whittaker, Senior Biblical Studies Lecturer at Trinity College, Melbourne, and a regular contributor to the conversation.
Thank you all for being here tonight, and thank you, Gordon, for the invitation. You've just heard from two very clever legal minds who've given us some insight into the complexities of the law on this issue. I am not going to even attempt to speak as a lawyer, for I am not and cannot. But as I understand it, I've been asked to respond, and particularly to give some theological reflections on this issue. I want to note at the outset that we are dealing with fraught terms, and they cannot possibly be defined in the 10 or 12 minutes I have, but that what religion is hotly debated amongst theologians. What is the secular and how that is manifest, even what human rights are and whether Christians should be for or against them. These are all things that are entire conversations of their own. But I want to come back to some basics and ask some questions about what freedom means in the Christian tradition. How does God enact God's own freedom? And does the Bible say anything pertinent to these issues? And before I do that, I want to note whose voices are not in the room. At this moment, we're primarily having an in-house Christian conversation. There are no Jews, Muslims, Hindus, Sikhs, Buddhists on the panel. I'm not going to speculate on the sexuality of others on the panel, but I'm not gay, which means I haven't been at the vulnerable end of the conversations we've had in our society recently. And so the three of us speak from a place of pretty high privilege. And we gather here on a Friday night while a few kilometres away Jews are keeping Shabbat, often having to employ armed security because of the frequency of death threats on their communities as they worship. Those who track data will tell you that our Muslim sisters and brothers face far more discrimination and prejudice than Christians do. This is the context in which we speak, and there are real issues of religious freedom here. So I speak as a Christian, but I want to say that whatever we would defend for ourselves this night, we must be prepared to defend for those of all faiths and none, even where we find their views difficult and grating. There are two key questions for us, I think, as Christians. What is the gospel? What is the core of our faith? And how best do we proclaim it? And I want to start with the second, because we always proclaim the gospel in a certain context. I find it astonishing that the church, which has just been exposed as a systematic perpetrator of violence and abuse against some of the most vulnerable in our community, that is children, by a royal commission no less, that this church in some places, is seeking further protections under the law. Now, we've seen that some exemptions are important. But what is going on here, I think, is a sense of threat due to the change in the Marriage Act. And that the same-sex marriage plebiscite was a triggering issue for this conversation is telling. The mainstream Christian church finds its traditional values at odds with 62% of the society, acknowledging, of course, that there's crossover and some of those Christians are in the 62% and all of that. But more than that, the public social endorsement of homosexual relationships taps into a deep patriarchal insecurity about masculinity, sexuality, and power. Power is being challenged, male power, heterosexual power. So are threats rising, or are we hearing the dying cries of Christianity, of Christendom? For the first time in a long time, the church failed to influence a public debate to its own ends, despite enormous political pressure, lobbying, and vast amounts of money being spent by conservative Christians. The plebiscite vote was lost. But to have a constructive conversation about these issues, we need to be talking about more than same-sex marriage. There are serious issues here about human rights and human dignity, about religious freedom, and about the kind of society we want to be. I, for one, want to live in a society where a Catholic hospital might say, "We do not offer assisted dying in this place." I might even want them to say we have a particular sacramental view of marriage. I do want that conservative school to be able to teach to its own faith agenda, although we might draw the line and say you can't call a 6-day creationist literal view of creation science. You can teach it in religion class. And we might also draw the line at the kid who is facing death because the parents' religious views would deny them a blood transfusion. So there are lines we draw. We do this all the time. We already negotiate these spaces. As a biblical scholar, what might our scripture and tradition say to some of these issues? The Bible actually says very little about freedom. In the whole Old Testament, the word for freedom is only used once in Leviticus and about 11 times in the New Testament. And usually it simply means the opposite of slavery. And of course, terms like religion, democracy, rights, these are all entirely foreign to a biblical worldview. So how do we think biblically about these issues? And here we're circling back to my first question: what is at the core of our faith? What is the gospel? At the heart of the Christian gospel is a Saviour who revealed God's love and desire for humanity through voluntary suffering and identification with the vulnerable. A Saviour who challenged the religious institutions of his day when they were unjust, and who chose to die at the hands of a state rather than fight military might with all the divine power at his disposal. So Jesus embodies for us the way of God and the way of divine power, a self-emptying, self-giving, vulnerable love. And when we forget that, we forget the gospel. But we can also say something about the nature of God's own freedom in the biblical tradition. If we take as a starting point the sovereignty of God and that God is free to act in whichever way God chooses, what we see is God chooses relational freedom. God chooses to bind God's self with humanity. The Mosaic covenant is unusual in its ancient Near Eastern context. It's notable for its mutuality. This is not how gods behaved in the ancient world. A sovereign declared their sovereignty and the people did as they were told. But in the Old Testament, God chooses to negotiate that space. The covenant is spoken and assented to by the people. We also have one potential model for what a pluralistic good empire might look like in the Bible, and it's not actually Christian or Jewish, it's Persian. When the Persians defeated Babylon, they encouraged the Jews to return to their homeland, to rebuild the temple, to reclaim their faith. There was an acknowledgement that people's cultural and religious heritage was important for human flourishing. The Persians gave us back Judaism, arguably, without which we would not be here. So we have a relational God who chooses to negotiate and work with us. So when we talk about religious freedom, our own freedom to act as followers of that God, we are always talking about something that is relational, that is dialogical. It is not about using our freedom against others, but rather, as my colleague Scott Kirkland said in a recent conversation article, with others, freedom with. When we think of biblical law in terms of how we're to act, there's a couple of things we can say too. The first is that the Torah, the Old Testament law, is actually a grace-filled and free law. Again, it is there to guide Israel, but the grace is extended to those who are not Jewish. Shabbat, Sabbath, rest, was to be given to the slave and the foreigner in their midst as well. So the good gifts of the law were extended to others. But one of the threads of biblical law that runs throughout time and time again is love your neighbour as yourself. And I would suggest that this is a little stronger than the do unto others claim. It's stated first in Leviticus, but it appears several times in the New Testament, 3 times in Matthew. Paul twice calls it the central law. And even James, who doesn't agree with Paul on very much at all, also cites it as the law that should govern all laws. Love your neighbour as yourself. In doing this, you fulfil the entire law. So what does that look like? A quick example from Israel Folau. If you followed the news story, you will know that he's a rugby player. He has over 300,000 Instagram followers, and he made the news earlier this year, was it? Yes, for a comment on his Instagram page. Now, I firstly want to say there's a lot that Israel Folau is doing well. He has chosen to use his public platform to live out his faith. He has resisted the privatisation of faith that society often asks us to do. What he came to the news for is he'd put up a little meme on Instagram of God's plan and your plan, and then there was a whole conversation. There's like 6,000 comments in there. And buried in them was someone who said, "What is God's plan for gays?" And he responded, "Hell, ... unless they repent." Now, many of us in the room would disagree with that theology, although if you grew up in the evangelical end of the church, you also recognise it and the worldview it represents. Does he have the right to offer this opinion? Yes. Is it legal? Yes. Was it wise? Was it loving? No. And the measure for me is, imagine the 14-year-old boy who idolises Israel Folau, but is also thinking about his own sexuality and reads that on his heroes page. What does that do to the vulnerable in our community? So while we need the law and we need the lawyers, and we might want to say, yes, Human Rights Act would be a good thing for our community, we also need to talk about responsibility We need to talk about how to be a public Christian in a way that is loving and relational and invitational. It might seem simple and naive, but in a rapidly changing society where people often know very little about the Christian faith, we need to speak in ways that are new and fresh and loving. And if we take Christ as our model, then we best proclaim God at precisely the point we give up our power and align ourselves with the most vulnerable in society.
Thank you, Robin. I trust you all have your questions firmly in your mind, and shortly they'll be passed up to me and I'll share them around. But a couple of questions from me just while those questions are being assembled for us. Frank, can I ask you something about the way in which you approach this on the Commission, without, of course, revealing any of your findings, but just some basic stuff, like we've been alerted to just even the definitional problems of religion, and I believe the definition you're working with contained the word supernatural as part of the sort of standard definition of religion that you may have been working with. Another word that occurred that's critical is the word to make manifest. That is, it's not just belief, it's the way those beliefs are expressed. How did the Ruddock Inquiry come to terms with those definitional questions? Was much time given to that?
Well, on the definition of religion, no, we weren't too hung up on that. We thought that the High Court of Australia in a couple of judgments has had definitions which the scholars like Carolyn Evans have said are good, workable definitions. So they're broader than just supernatural, but yeah, some belief in the transcendent or a great principle which helps to shape one's perspectives and the way one should act. We saw that as taking in ideas of religion, that religion on some level it might be like belief, like a political belief, but on others it's like a sense of identity, almost like race or ethnicity. So religion is, it's a polyvalent sort of notion, but for us the basic approach was to say that what Australia wants to do as the pluralist democratic society we are, we've signed up to a lot of human rights instruments, and yes, there can be discussion about the philosophical or theological worth of that, but particularly for a country like Australia that doesn't have a constitutional Bill of Rights, the fact that we want to be seen to be a good international citizen, being true to the obligations that we've voluntarily undertaken, is important. Now, the critical instrument on this is what's called the International Covenant on Civil and Political Rights. Now, that includes Article 18, which is the key one in relation to religion. So it basically says that all of us are entitled to believe what we like, or not believe, and there's no limit on that. But in terms then of the manifestation of one's belief in religion or conscience or whatever, the state can impose limits on that if there be a legitimate public interest or it's interfering with other rights or whatever. And then, finally, in Article 18, there's talk about some of the things that Sharon was raising about parents educating children. Doesn't speak in terms of a right there, but at least respecting the liberty of parents and guardians. So our approach was basically to say, all right, that's what Australia has signed itself up to voluntarily, then we lawyers and elected politicians would want to ensure that the legal architecture was sufficiently robust as to give respect and recognition of those three things.
Sharon, let me ask you. Frank has given an outline without going to what the Ruddock body will say to us, that seems to argue towards a more coherent expression, a tighter expression of things such as a freedom of religion bill or a human rights bill. What's your view on that?
I think, are you asking me whether I think there should be a Bill of Rights?
Yes.
I think my response to that would be that the context in which this issue arose was out of the same-sex marriage debate, and I believe that, as Frank has explained, the issue of freedom of religion came up in the context of that debate. I don't know that I think that the Human Rights Bill, it's a bigger agenda than this particular issue. So my own preference would be for a freedom of religion legislation rather than a fully fledged Bill of Rights. And I guess I'd share some of those concerns about, if it was an constitutionally entrenched Bill of Rights, then you have the High Court as the ultimate arbiter. So I doubt that would be the case. But I think that was the context in which it arose, and my view would be that it's not necessary to sort of use a hammer to sort of crack a nut sort of thing. Yeah.
And Robin, briefly for you, before the audience questions flow, you raised an example of where some of these issues do collide in a potential resolution. You raised some would call it sort of an old chestnut of six-day creation, and okay, you might believe that in terms of your religious belief, but you've got an issue in the science classroom. Okay, keep your religious thoughts to the religious studies room and your science project to the science room. But for the student, doesn't that inevitably invite cognitive dissonance? That is, it leaves the student in an almost impossible situation, because ultimately the student has to be asked to make a subjective judgment about what are the facts of the situation, or how am I going to operate in my life with regard to this information, which can affect the way you view the world. It can't really be left at that. It's playing a false game, really, to leave it at that.
Yes, and this is a very grey area, except I would say by saying it belongs in the religion classroom, not the science classroom, is we move beyond facts and acknowledge there are different ways of knowing and approaching things, and I don't think that has to cause cognitive dissonance. I think that can hopefully be a way for students to learn to negotiate the world they live in. But I think where I would sit uncomfortably, and there are American states that let schools teach creationism as science, I would be worried if Australia went down that route, because I think we would actually want to say as a community there's certain things that are agreed upon bodies of knowledge that we would want all students to at least be exposed to. So even if they learn it as, this is what scientists will tell you, they're at least learning it's out there in the ether.
Did you want to respond to that, Sharon, at all? If you don't, that's fine.
I'm not a scientist. I guess I'd agree, but I would also say it's a shame to teach science without religion, in the sense that, I mean, there are many, many scientists of renown. Francis Collins, chairman of the Genome Project, John Lennox, those people who would argue that there is a God behind that. So to teach science without religion, I think, is just as problematic.
All right. Enough to kick the debate off. We have some questions, and okay, we've got a couple of pages of questions here. A question for Frank. Frank, you say that the Commonwealth has no power in our federal system to legislate across all areas of discrimination, but as a signatory to the International Human Rights Commission and exercising the very broadly interpreted external affairs power, couldn't the Commonwealth pass a Human Rights Act, a Religious Liberty Act might be a bit more difficult, that applied to the whole country and overrides our inconsistent state legislation?
It could.
Here endeth the lesson.
But given that there's a whole plethora of state, territory and Commonwealth laws, those who think that a Liberal National Party government, or for that matter even a Labor government, would simply pass a wholesale Commonwealth legislation overriding what is done in all the states and territories, they would have rocks in their head, particularly as you in Victoria have a Charter of Human Rights and New South Wales, the most populous state, does not. Now, as you know, you Victorians are special. You're very special. And the thought that the Commonwealth would come in and bring in a provision which overrode completely your Charter of Human Rights, which would not measure up presumably to what your charter is because it would have to appease the New South Welshmen who want something less than that, I think starts to give you an idea of some of the complexity of the issues. And if you're in any doubt about that, look at who chaired our inquiry. It was Philip Ruddock, who had been the Attorney General in the Howard government. Now, the idea that you would simply have the Commonwealth coming in and overriding everything the states do, then you might get that from the Greens, but I don't think you'll get it from the Liberal Party.
Okay. What are the implications for Christian schools and other organisations in relation to freedom of speech of the new marriage law? For example, will a Christian school be able to teach that marriage is strictly between a man and a woman? Have we got various views on that? Who would like to start?
If the Christian school is offering a legal studies course, then of course the students would fail if that was the answer that was given. I think a Christian school would be perfectly entitled to teach in religion class that from a religious point of view, this is what we regard marriage as. But in terms of students who want to know what is the civil law in Australia, or New Zealand, or the United States, or Canada, or Spain, or Portugal, or etc., then they would need to know that marriage as an institution in civil law can include a union between two persons of the same sex.
Any other comments? None at all? We're in agreement. All right, we're in furious agreement here. Let me ask another one that perhaps just expands something that's been in the public arena, and that is, I mentioned the science room case. The other one that's been in the news media and used to illustrate both sides commonly is the wedding cake example. We've all heard of the wedding cake example. Let's see if we can get some elucidation as to what that means from each of our speakers. So briefly, if we could start, well, perhaps Sharon, we'll start at your end and come down with the wedding cake, and whether or not we can put sort of icing and frills on the wedding cake.
Okay, I think in this situation there is a clash of rights, and I think there's always no bright line answer when there's a clash of rights. And I think this is just another one of those scenarios, and it's going to involve a balance of rights. As far as the same-sex couple are concerned, their right is that they would argue that they have a right to be provided with the goods, the service, and if they're refused, then their consequence is dignitary harm, which is no doubt real harm. So in a sense, and it's possibly discrimination, although it may not be. I mean, for example, if the mother of one of the same-sex couple who was a married heterosexual woman came in and ordered the cake, then to refuse the cake is not really discrimination. The issue for the cake maker is if they are forced to act against conscience, then their freedom of religion is violated. And if they don't, if they stick with their conscience and refuse, then they're likely to be pursued legally and to be forced to pay significant compensation. So it's a difficult one. I don't know what the answer is, but what I do believe is that there are two rights at play. It's not one-sided, it's two-sided. And I think acknowledgement should be made that it's a violation of the cake maker's rights, or it's a violation of the same-sex couple's rights. And I guess it's one of those situations where I think if we truly desired to show true tolerance to each other, it would be open to the gay couple to have the cake made by somebody who was willing and happy to make the cake, provided they could get that service without any issues. They would then get the cake they wanted by a person who's happy to share in their festivities, and the religious person would get to act in accordance with their conscience. So win-win. Are we prepared to behave like that? That would be my issue, my response.
Robin.
I feel like this is a bit like a mythical unicorn with, frosting on top. I know we've had 1 or 2 US examples, and we need to be very suspicious of those because they're often being promoted by groups who are seeking to make a wider political point. And I think this, at one level, is where the language of rights starts to stop being helpful. If you're a wedding cake maker who feels that you can only in good conscience make wedding cakes for, one presumes in this worldview, heterosexual couples who haven't had sex before married or been married to anyone else before, and therefore not divorcees, are you going to question everyone who walks in your door on their sexual life and commitments before agreeing to make a wedding cake? I mean, we're just in the area of absurdity here. And if that's actually your... thank you, does that work better? And if that's how strongly you feel, maybe it's time to get out of the wedding cake making industry. I mean, we just need to have some common sense here. Yeah.
No,
Frank,
it's
if
one
I
of
could-
those issues on which I'm pleased I don't live in the United States. I think we Australians are much more commonsensical. I think we're a little more laissez-faire. The provision of goods and services in the market I don't see as a freedom of religion issue. I do see that there's some freedom of speech questions, if I might just give a couple of similar examples. The person who walks into the Jewish baker and says, I want you to make a cake that says, I think Nazis are wonderful. Well, no, sorry. I just don't want to express myself in that way as a Jewish baker. Or the ones who come in to the person who's known to be a gay baker and say, well, you bake us a cake that says marriage is only between a man and a woman. Now, I think there are some freedom of speech issues. There may be 1 or 2 test cases about freedom of speech, but I think at least in Australia we'll get over that. And basically, I think any baker or any other service provider who's known to be discriminatory in an adverse way, they'll lose their trade. And why are you doing it in the first place? So I think we'll find a pretty common sense level on this, and I don't think it's a matter that requires extra legislative activity.
Here's another question that I'll get each of you to give us a brief observation on, and it relates to, indirectly to the gay baker story. Is it possible that the backlash against religious liberty is a direct result of the egregious misuse of religious privilege? If Christians had been kinder, perhaps they wouldn't be so despised. Quote. Who'll go first?
Yes.
Robin.
It's possible. Yes.
We all agree?
I do. I might say one of the privileges I've had, 10 years ago doing the National Human Rights Inquiry and then being on this one 10 years later, you get the opportunity to get around and listen to the Australian community generally. And I'd have to say 95% of people, wherever they line up on debating the issues, they're decent, they're happy to engage, and they're happy to be very tolerant. And at either end of the spectrum, there are some people who you find, or I find, very unpleasant, and you say, well, thank God that one's over. But I think in Australia generally, our capacity for civil engagement is extraordinarily high, much higher than what we see in our Parliament at question time.
A related question. In her recent paper, Protecting Freedom, Protecting Privilege, Church Responses to Anti-Discrimination Law Reform in Australia, the Reverend Eleni Poulos of the Uniting Church writes, in focusing on the protection of their institutions, the Church submissions to parliamentary inquiries into human rights legislation failed to articulate the Christian vision or mission of caring for people in need and explicitly opposed laws that sought to uphold the rights and extend protections of people who suffer certain forms of discrimination. Why should we take the current concern of Australian churches for the protection of religious freedom seriously when most of these churches have previously opposed attempts to enshrine human rights Australian law? And I take it that's meaning churches as institutional bodies.
I happened to read that paper yesterday, and Eleni in it points out that of the numerous submissions in the 2012 to 2013 draft Human Rights Bill, with the exception of a submission by Uniting Justice, all the other church submissions that reflected 8 different denominations not only argued to increase their own sort of privilege under the law, but also basically failed to articulate what that question says, articulate any kind of Christian mission that might be towards the vulnerable and the very people that were... And I think I was trying to point to some of those things in my comments that, you know, when we as the church, and I speak as someone within this church, and I'm critiquing it from within in the way that we sledge off our own family sometimes, but we still love them, really. You know, when we as the church behave in this way where our primary goal is simply to maintain position or put up borders or protect our power, I think we've failed to really behave like the Christian church.
Other comments? No?
I mean, it's a while since I looked at the submissions, but those like the National Council of Churches, I don't think you can categorise like that. So have a look on the website.
You can read Eleni's article. It's worth reading. And sorry, the other thing she articulates in there, which came up in our conversation this afternoon with some of us, is some of that opposition to having a Human Rights Act was perceived to be precisely because a Human Rights Act would open doors towards something like legalisation of same-sex marriage.
If this debate has been couched in the frame flowing out of the same-sex marriage debate, are we at risk of overlooking some other quite serious issues which confront us as a community on the issue of civil and political rights that profoundly affect churches? Frank, you've recently commented on the Foreign Influence and Transparency Bill before the government, the Electoral Legislation Amendment Bill. These could have a profound impact on religious institutions and individuals with religious convictions. Yet we're not seeing much discussion about either of those pieces of legislation.
No, but I would say that, like in the Ruddock inquiry, I mean, yes, we knew that the plebiscite was the trigger for this inquiry, but it wasn't just about that. And so it's questions about, well, how do we as a society of the 21st century, with the increasing religious pluralism, and there are lots of statistics you'll find in the report about the decline of affiliation to Christianity, the increase of unbelievers, the increase in the Muslim and Hindu communities, those sorts of issues, where we're part of a world here in Southeast Asia. The Pew Research indicates that the number of people who are unaffiliated religiously is declining rapidly in this part of the world. So we're going to be a bit out of sorts with our part of the world. That those who are religiously affiliated globally, it's due to increase, but we're one of the societies where it decreases. But given those realities, it's therefore necessary for us to make sure that the legal architecture regarding religious freedom is appropriate, and not just to deal with issues such as same-sex marriage.
Other comments?
And in fact, I can say, you know, we have recommendations not just regarding law, but there have to be things like better education, better garnering of statistics about, religious violence towards the Islamic community, towards the Jewish community, things of that sort.
Here's a positive question. How can we create forums when interfaith voices are around the table together to consider issues of religious freedom, not to mention creating greater understanding amongst one another? You've all probably thought this in your own mind. How do we get around these issues? How can we bring people of multi-faith perspectives together?
Well, it's just by, crossing the bridge. I have recently become the patron of the Australian Liberian community in Sydney, and I didn't know how this happened, but it turned out I had spoken at a Ramadan Iftar dinner in Western Sydney last year, and so the Liberians who were there said, who should we get as our patron? And someone, a local politician, said, well, get the guy who's just given the speech. Now, if I hadn't been there at the dinner, I wouldn't a couple of weeks ago spent a couple of hours driving out further west than Mount Druitt and dressing up in very garish gear to spend a night of cultural celebration with the Liberians. Unless you establish the relationships, it doesn't happen.
I think it is relational, but until that comes naturally, I think we might need to be a little bit more intentional about extending invitations and moving outside our comfort zones. I do find, having spent a decade in the US, I do find Australia, we still seem to be a little bit siloed, at least in Melbourne. I can't speak for other cities. So there's certainly work to do there. And I think the Christian church, we've had a pretty successful ecumenism movement, and that has taken enormous energy internally. But I think what's been lost in our focus on ecumenism is the interfaith conversation. And I actually think that is going to be where we need to go for the next few decades.
Next question. I would love to know what the implications would be if we were to fully implement in Australian law the sections of the International Covenant on Civil and Political Rights related to freedom of thought, speech and religion. There's a positive spin on a question that's been handled with some sort of deference. Sharon, do you want to have a go first?
I think you would still end up with clashes between Article 18 rights and other rights. So you would still have the problem of where the rub is when those rights intersect. So I don't think it would, it would create problems as well as solving some. I think it would give obviously stronger protection to freedom of religion, and I think it would impose more restraints on governments as regards the extent to which they can legislate to restrict religious freedoms, because Article 18.4, I think it is, talks about that the freedom to manifest one's religion may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, morals, or the fundamental rights and freedoms of others. So there's strict limits, and it would certainly, it would lift the protection of freedom of religion, but it's not going to solve the fact that there are scenarios in which it's going to rub other human rights, and there's going to have to be decisions made as to how those rights are, respectively respected. To what extent does one give way to the other? And that's always a question of proportionality and things like that. So it would strengthen freedom of religion, but it would not, it's not going to answer every question, that's for sure.
The way you can approach this is imagining, you could have a constitutional Bill of Rights, like the Americans. You could have a statutory Human Rights Act. You could have some form of Religious Freedom Act. You could have a sort of Religious Discrimination Act. You could have a comprehensive bringing together of all of Australia's national discrimination laws into a general anti-discrimination legislation. Or you could maintain the quilt work that we've got, where basically religious freedom has been carved out as exceptions or exemptions in things like the Fair Work Act or the Sex Discrimination Act or things of that sort. Now, if you stay on that bottom level, the problem of the public discourse in Australia is people saying, oh, there you go, there are those religious people, they just want to keep those exceptions to the general law. Well, they're the exceptions to the general law, in a sense, by historical accident. Given there wasn't a general religious freedom law enacted, then when we came to enact something like the Sex Discrimination Act, there was a need to look at a carve-out, which was the way of protecting religious freedom. So how this might be done is, first of all, by the public discussion that what this is about is not special pleading for religious people, and it's not special pleading for religious institutions. It is about providing the space for pluralism within a society where we're big enough to provide the opportunity for everyone to enjoy the fullness, the plenitude of their human rights, whether or not they are religious, whatever their sexual orientation, whatever. So that's the challenge.
Okay, let me extend that a little. And Frank, go back to your opening statement where you gave us a little insight into constitutional history on these matters, because a question we have here takes us back even a little further to a debate that happened in the 1880s and 1890s with regard to education in Australia. The great education debates, free, compulsory and secular. And then, of course, we could come forward to 1964, when Sir Robert Menzies decided that Commonwealth money could go to funding science buildings in schools. Is this where this dreadful debate could be handled much more efficiently by getting rid of the whole sort of link between funding and Commonwealth funding and the way you were able to teach in schools? That is, if you broke that link and said, look, if you want to teach your own faith tradition, that's fine, but don't expect government money for it to support it. And if you're going to have government money, then stick to the free, compulsory and secular line.
Well, I mean, that's one argument, but I think the other argument is to say that the education system generally of the nation is enhanced where there is a plurality of options, and where it's said that, yes, religious educators want to step into the space for educating their own, fine. They will not get the full government funding that they would get if they were in the state school, but we will, and this is what the Gonski debate's been about, hasn't it? What's an equitable distribution of those funds between the religious sector and the state sector? Now, I would have thought that in Australia we've reached the stage that the 19th century option is not the 21st century solution. And I think that maintaining the plurality of school systems is appropriate, but what is the equitable distribution of funds, I think, is a very contested issue, and I don't pretend to be across that.
I would want to add that I think we've, while I understand historically why some of those decisions were made, I think it's been a huge loss to our society. We are not a religiously versant, educated society. And I'm not meaning necessarily the sort of faith-based approach of going in, and I've been there and done that as a religious education person who goes into the local primary school for that half an hour. But I actually mean something that's more like a robust world religions education, or something in the tertiary sector. You know, I'm part of the University of Divinity, but we're a specialist university precisely because teaching theology cannot happen at Melbourne University and in other places. And I think that's a huge loss, because we're not being able to have the kind of conversations with each other and I think it feeds into a kind of a general disrespect at times for the place of religion. That it, I mean, as soon as you write something in the public sphere, there's always someone who comes in with the fairy tale and the, you know, these sorts of, just a disregard for religion. I understand where that comes from, but it also means there's no appreciation that whether you're a person of faith or not, these are deep intellectual traditions, and we're just not able to sort of manage that in Australia, I think.
Sure.
I think it.
I have that one. It's on.
I think it's part of a. I think it's part of a larger question about the difference between secular and secularism, and I think that secular, in its proper sense, really means that the state is neutral about religious claims and truth claims rather than hostile to them. And I think secularism is more a view that religion should be kept out of the public square, kept within the private realm. And I think the schools issue is part of that larger debate about the proper place for religion in the public square. But I do think that we're seeing that we're trying to, we've to a degree redefined a secular Australian state on what might be called secularist terms, where there is a hostility to the expression of religious views in the public square. And I tend to agree that with Robin, that's a real shame and a loss.
How much, and I get all of you to give me a view on this, do you think that the way in which the current debate has been waged in Australia is the responsibility in some ways of both sides being entrenched and simply content to hurl anathemas at each other? And is this a function of the issues themselves or the way in which we as a civil society have become to behave over the last couple of decades? Frank, you mentioned don't take parliamentary question time as an example. How much is the sort of background white noise, if you like, of the way discourse in society has gone on been impacted the way these debates have been conducted?
I think that's a huge social issue for us. It's perhaps part of being in a media age where it's all about the soundbite and the controversial. I mean, no one wants to read a carefully nuanced, boring article that balances numerous views. They want the sensational piece that, hurls something at someone else. So I think this is watch Q&A. It's deeply problematic. It's just talking points. No one's actually entering a dialogue where they might walk away having changed their mind. And it's partly why we need things like this. I mean, Gordon organised a RASP thing a while ago with one of Sharon's colleagues who I disagreed with on almost everything he said. But we were able to have a really interesting conversation, and some of the things he said, I went away and I thought about them and I did shift my views slightly. I mean, that's what dialogue looks like, not talking points to sort of beat someone with. So it's a massive issue. And universities need to, we're part of the people who can, and media people, who can model something different, I think.
As far as universities are concerned, I think there's a concerning trend, not so much in Australia, but in other Western democracies, to really have these things called trigger warnings, and there's a debate at universities is really now quite restricted in some ways, and I think it's a shame because we don't debate deeply the way we used to. I think the internet, there's obviously a problem there. We stay within our echo chambers. People can make all sorts of comments without putting their name to it. Very recently, the defamation law statistics are now showing that there's a lot of defamation actions now brought against people for their comments on social media, whereas traditionally your defamation action would be against a mainstream media organisation. So the law's catching up with it, but I think people think that they can say anything they like on social media without any repercussions, and that's contributed to this horrible level of debate. we just break into our silos and say what we like. And I agree, we don't discuss deeply, we don't listen, and I think it is symptomatic of society in general.
I would say, though, that most of the people who came before us at the Ruddock Committee, I think, were deeply respectful of alternative points of view. And despite the things that have been said against the plebiscite, and I was never supportive of there being a plebiscite, but once there was, and once it was carried so strongly at 62%, I actually think that helped us as a society to say, right, we own that, that's now the result, and we move on. And I think there is still a strong spirit in the Australian community generally of, you know, that's done and dusted and let's move on together. And I think we've got to encourage that.
We've reached the end of our list of questions. I think the debate and the discussion, rather than a debate, has been a really healthy one for all of us. And I'm very grateful for the opportunity to listen to three distinguished voices who have thought long and hard about these issues. So if you join me in giving them a round of applause, and Gabriel McMullen will now join us to close the event. Gabriel.
Thank you, John. So I have the privilege on behalf of you all of thanking all those involved in making this evening a success. And I'd firstly like to acknowledge the Collins Street Baptist Church. This is the ideal venue for this conversation, theology in the public space. We're right in the heart of Melbourne. We've got bustling streets outside, and we're very, very grateful to the church here for the opportunity to use their space again. I'd like to thank John Cleary for being our facilitator this evening. He's brought a lively conversation to life, and all his expertise in the media has been part of this fruitful engagement. So, John, thank you very much. I'd like to thank our two respondents to the main speaker, Dr. Sharon Roderick and Reverend Dr. Robin Whittaker. They've played a key role this evening in ensuring that this was a real conversation, and you've obviously put a lot of work into preparing for this, and we're very grateful, Robin and Sharon. Thank you. And then to Professor Frank Brennan, who, despite the non-release of the Ruddock report at this stage, provided a very meaty contribution. Frank,
I'll be happy to come back.
You make so many public contributions in so many ways. I think in thanking you for tonight, we thank you as well for all of those contributions you make. And of course, I need to thank you, our gathering this evening. Without you, we couldn't have had a conversation. Again, it's the first night of winter, it's pretty chilly, but thank you for being here, and we hope you'll be at many more of these occasions when the Centre for Research in Religion and Social Policy brings issues like this to a public gathering, and your points of view are so important to us. And finally, to thank three people who really made tonight happen. Firstly, Dr. Gordon Priest, who is the director of our centre. He had the vision for this evening and he did most of the organising. And Gordon, thank you very much. And then two people more on the media side. So Meg Nelson from the university for her media work and promotion, and Bassam Morgan from St Athanasius College, who has live streamed this evening, and we noted that there's a number of people who are perhaps home by their warm fires, but were also partaking in this evening. So thank you all very much. We look forward very much to seeing you again at one of these gatherings. Good evening.
Thank you. Yes. Thanks, Gabriel.
What are your plans now?
Adele Howard is going to pick me up at about 20 to 9, quarter to 9, I think. Yes. She was at some event at ACU, so I'll have a quick supper with her, then I'll stay at Park Drive and go back to Canberra in the morning. Yeah. Pleasure. Yeah.